Hi, folks. Good morning. My name is Greg McLawsen. I'm the Affidavit of Support Lawyer. I represent green card holders in federal lawsuits to enforce the USCIS Form I-864. I noticed a decision that was handed down the other day in the Eastern District of Michigan. This is November 29th. It actually wasn't one of my cases. It's the first time I've seen a published decision in a case that wasn't one of my clients in a while. And it's kind of an important one, so I thought it would be worth mentioning. There's this issue in affidavit of support lawsuits about how you calculate damages, which is just the legal way of figuring out how much a plaintiff can recover in one of these lawsuits. So if you're a green card holder and you sue your sponsor, when it comes time for a court to determine how much you get, those are called damages. One of the issues has been whether in a case where we're looking at multiple years, does the court lump all of those damages together and calculate them all together, or look at things on an annual basis? And here's why that matters. It's really common in these cases. I see this all the time with my clients, where you have a situation with somebody being unemployed for 1 or 2 years, sometimes more. And then they get a job, sometimes a well-paying job. And it's only then, when they've kind of got their life put back together, that they have the bandwidth to think about a lawsuit to recover the money that's owed to them by their sponsor. If you look at damages, the amount that's owed to the plaintiff across all of those different years, sometimes the income earning years can wipe out a plaintiff's potential claim to support. Damages in these cases are always calculated as the difference between a person's income and 125% of the poverty guideline. So if you have a couple years where the person's earnings are so-so, then a couple years of unemployment, and then the person's back into employment, if you look at those multiple years together, they might average out such that the person was earning on average over 125% of the poverty guideline. So if a court were to look at these years aggregately, that means that the person might not have any claim to damages and might walk away with nothing. The case that was handed down in the Eastern District of Michigan 2 days ago follows the approach that is taken by the majority of courts. And that says that damages basically reset every year. So when we look at what a plaintiff is entitled to, we look at that on a year-by-year basis. And earnings from one year do not spill over into the other year when we calculate damages. This means that if you're unemployed in the year 2020, get a job in 2021, it doesn't matter how much you earned in 2021 when it comes to your claim under the affidavit of support. The only thing that a court looks at are your earnings in that year where you were unemployed in 2020. It's really important because this is a scenario we see pretty often. One common scenario in folks who are in marriage-based, or let's just say marriage-based green card scenarios, they will often come to me after divorce. And in that divorce, they might have gotten short-term alimony. It's very uncommon in the United States to have long-duration alimony. Some states call it spousal maintenance, some call it spousal support. So they might have had a few months or even a year of financial support that took their take-home to over 125% of the poverty guideline. But then that runs out. And then they come to me and ask if they have a claim under the affidavit of support. Well, if you were lumping years together, the person might not have a claim to support because those alimony payments might average out to wipe out a claim for affidavit support the following year. But this case from the Eastern District of Virginia says no. If the green card holder got alimony payments last year, even if they were substantial, it resets at the end of the year. And then if that person is unemployed, they once again have a valid claim for financial support under the affidavit of support. that's very good news. Another scenario that I've seen a lot is in cases that are heavily litigated. So if the defendant just wants to dig in and throw endless resources at these lawsuits, which happens occasionally, you can end up in a situation where a person has a couple years of claims to financial support, and then the litigation goes on a year or 2 years. And in that course of time, the person becomes employed. I have represented doctors, lawyers, PhD level scientists who eventually got back into a very high income earning situation. Well, if you look at years over the aggregate, those subsequent years of earnings could wipe out prior years of support, even though that person was left in poverty for multiple years due to the sponsor's breach of the Affidavit of Support contract. Cases like this one in the Eastern District of Michigan, which, by the way, follows holdings from the 11th Circuit Court of Appeals and the Belovich decision, that approach says no. If you, the sponsor, breached your obligation for 1, 2, or more years, you are still liable for damages, even if that sponsored immigrant gets back into the workforce later and earns a fair amount of money. To me, that strikes me as fair, because you can't, as the sponsor, you shouldn't be able to blatantly breach your obligation under this contract and then get out of that obligation simply because down the line, the sponsored immigrant is able to put their lives back together and get back into stable employment. So tip of the hat to the legal team who litigated this case in the Eastern District of Virginia. I appreciate the ruling from the court, and it's one more good piece of case law that strongly supports the right of green card holders to be able to meaningfully recover support under the affidavit. If you have questions about this or any other affidavit of support material, feel free to jump into the comments, and I'm happy to answer any questions that come up. Have a good day, folks.